Hi, Jeremy. How are you? We'll wait for Nura to come in and I'll let you guys get set up and everything you need to do.
Great. We're gonna run the PowerPoint?
Okay, perfect.
Okay. I'll have Nora be the host.
Sorry, what'd you say?
I said I'll let her be the host and let
Oh,
her run the PowerPoint. Okay. Good morning, everyone. Or I guess it's good afternoon. Thank you all for coming to Washington Metro Chapter of CAI's Maryland Legislative Update. Uh, every year, the chapter tries to undertakes a legislative update for its members and for us to come forward and try explain recent changes under the new Maryland law after following the General Assembly. And so what we will do today is go forward and explain the new laws that passed. We will not be focusing on the laws that were introduced that did not pass, address some local county issue, and address a pending case that involves many condominiums throughout the state of Maryland. So as a way of introduction, my name is Jeremy Tucker. I am a community association attorney and co-chair of the practice group of community association at Lurch Early and Brewer. My colleague Nora Rafadi will be co-presenting with me today. She is also a community association attorney at Lurch Early and Brewer. We are both active in CAI. I'm a former past president. Nora is a committee chair on the Maryland Legislative Committee and serves on the CAI's national LAC. And I've served as vice chair of the LAC. So we have both been active in community practice of community association law with CAI and in actively speaking and addressing legislative issues on behalf of community associations. And with that, I will begin the presentation and trying to keep track of everybody's time. This year, we've now concluded the Maryland General Assembly's legislative session. It was an extraordinarily active year. Several dozen bills were introduced. Some of them, if adopted, would have had wide sweeping implications. Almost all were not adopted, but several were, and we will be addressing those. The first bill that we wish to address is the SB 747, which cross-filed with HB 468. This bill relates to condominiums. And this was a very significant change dealing with insurance-related issues for condominiums. For those of you who are involved in condominium management or living in a condominium or serve on a board of condominiums, this is very important information. And it was a very large change. As you may be aware, the condominium associations are required to maintain property insurance and are required to, in the event that there is damage caused, regardless of fault, to a unit or the common element that is caused by an event that is covered by the association's property insurance, the association is required to promptly make the repairs. Because of this, and because of the number of claims that have been filed and the changes in the insurance industry, condominium associations have seen their insurance premiums skyrocket, sometimes doubling, tripling in price, and have seen insurance deductibles increase dramatically. So maybe 20 years ago, we would see a $1,000 or $5,000 deductible. We are now seeing anywhere from a $25,000 deductible into some of my clients have over $200,000 deductibles. And this has created economic impact on condominium and their unit owners, trying to make sure that they have proper insurance and are funding the insurance. Part of this law also provides that in the event that the damage originates in the unit owner was responsible for a certain dollar factor of the association's deductible. 20 years ago, in the event that the damage originated in the unit owner was responsible for $1,000 of the association's deductible. Several years later, it was amended to $5,000 of the association's deductible. And where it currently stands is that in the event that damage originates within a unit, regardless of fault, the owner of the unit is responsible for the first $10,000 of the association's deductible. So a great effort has been made over the years to try to increase that amount and to clarify some of the law. So what happens if it's less than the deductible? What happens in certain other situations? And so this year, a bill was passed that changes and raises this what we call the deductible pass-through and clarifies some of the language of the statute. So how it will operate now is if the cause of the damage or destruction originates in a unit, the unit owner is responsible for the least of the total cost of the repair, the association's insurance deductible, or $25,000. So what this means in practical sense is if the association's insurance deductible is $10,000 and the damage is $15,000, the unit owner is responsible for the first $10,000 because that would be the deductible. If the association's deductible is $50,000 and the damage is $27,000, the unit owner would be responsible for $25,000. If the association's deductible is $25,000 and the total damage is $16,000, the unit owner is only responsible for $16,000. So what this statute does is, in its most basic sense, is it increases that deductible pass-through to a maximum of $25,000 if the association's insurance deductible is $25,000 or greater. If the insurance deductible is less than $25,000, the maximum pass-through is the deductible. And if the damage is less than the deductible to $25,000, then the unit owner's responsibility is less, whatever that amount is. And this provides boards a little bit more breathing room. And when I've explained this to unit owners at other meetings and attending annual meetings and doing legislative updates for our clients, unit owners are naturally, surprised and a little bit upset because this is a great, going from $10,000 to $25,000 is a significant change. And it is, but it is somewhat reflective of the cost of to make repairs, which have, as we all know, have increased dramatically since COVID due to inflation and other reasons. $10,000 really doesn't cover much of the repair costs these days. And so it is an important step for our condominiums for two reasons. One, it allows for a greater recovery of the money that the association may have to incur in exercising and fulfilling its legal obligations. And two, my hope is, and we'll see, is that the somewhat specter of being responsible for $25,000 will make some unit owners more responsible for taking better care of their actions. Obviously, accidents happen, pipes break, those things occur, and they may not be known, but maybe it'll require people to pay greater concern about ensuring that their toilets don't overflow and they leave it there, or that their sinks or their bathtubs overflow and they allow that to happen. So we are hopeful that this may change behavior as well as create a little bit of financial breathing room, just a little bit, for our condominiums. The associations are required to provide annual notice. This was in the previous bill to their unit owners regarding the association's property insurance, the amount of the deductible, and what the unit owner's obligations are going to be. What this is what the statute also does for the first time is it requires unit owners to obtain their own insurance. For those of you who've been with us for a number of years, attending our seminars, or have worked with us, and you probably know that a number of years ago, the Maryland General Assembly amended the Maryland Condominium Act to allow for a lower bylaw amendment threshold to require unit owners to maintain insurance. And the position was, for many years, if the bylaws require unit owners to obtain their own insurance, then that's great. And the Maryland General Assembly took the steps to make it easier to require unit owners to obtain insurance. But with this law now, instead of stating whether the bylaws require it, now the statute affirmatively requires unit owners to maintain insurance over their unit and include the loss deductible of up to $25,000. And so this is a very important thing. So now all unit owners will be required to maintain insurance, and the association can require the unit owners to provide annual proof of that insurance. Just as a reminder, this unit owner insurance, what is often referred to as an HO6 policy, covers a number of things. It covers betterments and improvements made by any unit owner, personal property, relocation expenses, and the deductible. So this type of insurance is a great benefit to the associations, because the deductible will be covered under this HO6 insurance. And it ensures that unit owners are in a better position when their unit is damaged to recover all of their amounts needed to repair their unit to the condition that it was. Again, under the Condo Act, the association's obligation is only to repair the unit in the event that it is damaged to the condition as conveyed by the declarant, which does not include any betterments and improvements made by any unit owner, and does not include personal property or relocation expenses. So this will allow for those unit owners to have that type of insurance. I will give you a very good example. A unit owner, there was a renovated unit. Let's say all the units were selling for $350,000. This unit had been renovated and now is worth $700,000, significantly higher than all the other units. But it was destroyed in a horrible fire. Well, the association's obligation was only to restore it to the builder grade, which did not reflect any of the hundreds of thousands of dollars of improvements. But the unit owner didn't have insurance. And so they are in a position now that the unit they bought is not the unit that they will be getting back when we are done the work. And if they want that, they're going to have to come out of pocket. This prevents that scenario and also allows for the easier collection of the $25,000 deductible. There is one exception to this, is that if condominiums are comprised of only similar detached units. So basically, if they're single family detached units, this does not apply to them. This law is effective October 1st, 2027. So most bills that come into existence are effective generally October 1st of the year that they're adopted. This bill has a longer effective date, not coming forward until October 1st, 2027. And I believe that there's multiple reasons for that. One is to allow the insurance companies significant enough time to address and update their policies and premiums to reflect this change. And two, to allow unit owners sufficient time to obtain the insurance and to make sure that it's well noticed and all the unit owners receive ample notice that they need to obtain this type of insurance, and that this deductible pass-through will ultimately come through. So while this provides relief and a well-desired change to the Condo Act, we have some time before it becomes effective. And so what I've started and recommending that my boards do, and what I do when I attend board meetings and annual meetings, is I keep notifying the unit owners of this upcoming change. I think it's important, and I think it's to keep them doing it so they are aware of what they need to do, preferably so they get the insurance now, but so that they are aware of, and they're communicating with their broker if they already have insurance to see if there's any changes that are needed, and so that we are constantly communicating this with them. and in addition to the annual notice that we have to provide, that our clients have to provide. So I strongly encourage you as managers and board members to, if you're a condo manager or condo board member, to at least regularly keep hammering this point in this legislation in, so we don't have to deal with, well, nobody told me, nobody think this, and so that we are doing it because we want them to obtain insurance and we want them to know what their obligations are going to be to try to avoid surprise. Okay.
Okay. Next up, we have Senate Bill 7, or
I think there's a question, or if you want to take.
oh yeah.
Elmer, would you like to ask your question if you can unmute?
Yeah. Oh, you're not coming in. You're muted still.
I'm sorry.
Oh, there you go.
Yes, my name's Eleanor Gant. In our development, we have the association's water mains running through the lower units. So if there's a leak in that water line that causes damage, does the new law now state that the homeowner is responsible for repairing that pipe and the damage that is done?
So good question. This law doesn't change anything regarding who's responsible for what building component. So if your pipe is part of, if that pipe is part of the unit, and then the unit, and it breaks, then the unit owner would be responsible for the deductible. If the pipe that runs underneath the unit is a common element, then the association would be responsible for payment of the full deductible, and there would be no contribution from the unit owner.
Okay.
And so we can't answer your specific question because it really comes down to how that pipe is classified, whether it's either a unit or a common element. Okay.
Right. Okay,
Right.
Thank you.
You're very welcome.
We've also gotten several requests in the chat. Yes, this presentation will be made available. The other question from Judy said, does the state announce this change in law to the insurance carriers that are registered able to sell policies in Maryland?
I don't know, but I'm sure that their lobbyist was involved. Their lobbyist, we know, was involved in this legislation. So they are very well aware that, I mean, through that connection, since their lobbyist was at the table over this, I would hope that they are all aware of this change of law. And they generally receive legislative updates just like any industry does.
Absolutely. Okay. Moving on is the next bill, which was Senate Bill 758. This has to do with candidate and proposition signs. So up until now, Maryland condominiums, cooperatives, and homeowners associations couldn't restrict the display of candidate signs or propositions for 30 days before the primary election, general election, or vote. This legislation made a small little tweak, which was essentially expanding this from 30 days to 45 days, and also making it applicable to early voting. So essentially, moving forward, condominiums, cooperatives, and HOAs cannot restrict these signs and displays for 45 days before early voting for a primary election, general election, or a vote on a proposition. If there's no early voting, then 45 days before the primary election, general election, or vote on the proposition. Funny enough, the insurance stuff that Jeremy just went through goes into effect in 2027. This one went into effect almost immediately. It's probably not surprising why, given that legislators would love to have propositions and signs put up for them even longer than 30 days. So moving forward, condos, HOAs, co-ops, that 30 days is now switched to 45 days. Eleanor?
So it's important to note that where these signs can be placed are only within if you're a condominium or cooperative, within the unit, so on the window of the unit, or if it's an HOA on the lot. This does not allow or override prohibitions regarding placement on common areas or common elements. So it only relates to a unit owner's property.
That answered my question.
Thank you.
Because we have a no signs policy
Yeah.
and development.
So this would
I'm like, oh,
override the no signs policy. In like, for example, on the window, you cannot display any sign other than a real estate sign or something like that.
Right.
This would override that and allow it for 45 days before and then take it off 7 days after.
but only in the window and not on the lawn areas.
No, unless it's an HOA and they own the lawn. Yes.
Okay. All right. Okay. Thank you.
You're welcome.
Okay, so this is effective once it was enacted. So this is all set now. The next legislation you must have already heard about, given its interesting feature. This has to do with House Bill 956. And this isn't necessarily about condominiums needing to do anything. It is about the Department of Housing and Community Development, or DHCA as it's better known, is now required under this legislation to do a study on Maryland condominium buildings that are more than 40 years old. Their study is including a lot of interesting topics, from the number of condominium buildings that are in Maryland to the average age of unit owners, to the annual income of unit owners. And DHCA will need to report its findings back to the General Assembly by December 1st of this year. Interesting enough, there's been some controversy just because it's a study, but it's unclear how DHCA plans to actually obtain this information for its report. And it's unclear how they're going to plan to comply, but overall, this is DHCA's obligation between now and December 1st to do its study on condominiums in Maryland that are more than 40 years old. What it would look like, whether they're going to achieve it, is a little bit unclear, but it's just to let the condominiums know in case DHCA comes to them to ask these questions. You should know that it's related to this House bill.
And so there is nothing in the statute that compels the association to provide information for the condominiums. And of course, condominiums, at least that I'm aware of, for the most part, do not track the age of the unit owners, do not track, and certainly do not track the average annual income of the unit owners. So I think the legislation was it's well intended. That I think they're looking at these older buildings and wondering what the demographic makeup is and what are the financial challenges faced by these older buildings in particular. And I think that was the intent of the legislation, is to move forward other pieces of legislation that might help these buildings. But as of right now, it's unclear how, as Nora said, how this will come into effect, especially since the report is due in government work. And I know there's a few individuals who work for the government. Having the report done by December 1st, 2026 is a fantastic rapid turnaround time for actually getting a report of this nature accomplished.
Right.
But we look forward to seeing if this report does and what the results might be.
Absolutely. The next bill is specific to Charles County. So this has to do with Senate Bill 573. So this is going to apply only to board members and officers of condominiums that are in Charles County, as well as board members of HOAs in Charles County. Under this new law, you'll need to complete a training curriculum within 90 days after you're first elected or appointed as a board member or officer. For those who are already board members and officers, or who have been board members and officers since October of 2025, this is going to be within 90 days of you beginning your subsequent term. This is not surprising. It's the equivalent of having training either through the CCOC or any other entity that's been approved by the county or by the state of Maryland. You'll then also need to get a certificate that essentially says that you have completed this training program, and then the certification will be in effect for 3 years. So you would have to do this training once every 3 years. There is some language about the fact that if a board member or officer fails to complete it, then it can be removed from office or have their vote invalidated. We're not entirely sure what having the vote invalidated means in its entirety, but it's just to make sure that board members and officers are getting this training within the 90 days of them being elected. This new legislation goes into effect October 1 of 2026. So hopefully Charles County is able to, between now and then, clarify what trainings they've approved and maybe give a sample of the certificate that you'll need to submit to the county to confirm. Oh, sorry, I just saw a chat question come up, but I believe it was for the one beforehand and answered. But yeah, so this is for Charles County condominiums and HOAs. Also for our Prince George's County folks who are on the call, there was a resolution that recently passed called CR 005-2026. This resolution has a lot of requirements and a lot of different parameters that they're putting on Prince George's County common ownership communities. We've received a lot of questions. We'd recommend you touch base with your attorneys to maybe get a sense of how it would apply to your community in Prince George's County. But we did want to make sure that people were aware of this resolution passing, and making sure that you touch base with your attorneys to discuss it. And then next up, we have a litigation update on BEPS. I'm going to flip it back to Jeremy for the big BEPS update.
So this relates to condominiums and multifamily buildings. The state of Maryland has, as some of you may be aware, adopted building energy performance standards that requires each multifamily or condominium building to meet, which is basically working to convert any gas use to electric use in its most basic terms, is trying to eliminate or reduce greatly the use of electric gas and try to become more energy efficient. And the standards are pretty high in the state of Maryland and can require significant multi-million-dollar investment by condominiums, in my case, to meet these standards. And some of my buildings, we've been told there is not sufficient technology yet to even meet these standards. So this was a pretty controversial issue. In fact, it was enough controversy that Montgomery County was able to obtain a bill last year and passed that basically said that for Montgomery County, that Montgomery County standards will control, not the state of Maryland. Try to make it a little bit easier on Montgomery County properties to meet this standard. It is, certainly for my older buildings that are gas, you have gas boilers. This is a very significant piece of legislation. If you're not aware of it, please contact your attorneys to understand what this would mean for your properties. But what a number of communities, a number of condominiums, and a number of other organizations and entities have done is they filed a lawsuit challenging this law, They filed in the Federal District Court of Maryland. The case was, and there was two condominiums, one cooperative, and the Leisure World of Maryland, a corporation as far as the community associations go. And then there was a number of other organizations that joined and are really running the case, but a number of condos and community associations are involved. And the argument was and is that under the United States Constitution, which provides that in the event that the United States Congress passes a law that addresses an issue, this shall preempt any state legislation on the issue. And the argument that has been put forth is that under a certain law called the Energy Policy and Conservation Act, which governs the energy efficiency and energy use of gas appliances, that the federal law preempts the state law. And similar states have passed this law around the country, and it's been challenged on similar grounds, including the District of Columbia. This case was was decided already at the U.S. District Court level and found in favor of the state of Maryland. What the court found in that case is that this doesn't relate to gas appliances, but relates more generally to the use of natural gas and trying to restrict gas. So therefore, it is not, and moving forward with energy efficiency, which is not preempted by this statute. The district court in DC found the same. The district court in New York found the same, but a district court in California found otherwise. It found in favor of the argument of preemption. So what has happened since then is the case has been appealed to the Court of Appeals for the Fourth Circuit in Virginia, and the plaintiffs have filed their initial brief, and we are waiting for the state of Maryland to file their brief. And so as this works through the court system, it'll be some time, but the law remains in effect. Buildings continue to have to comply. It will be some time into the Court of Appeals makes their decision, and then it'll be determined whether ultimately it gets appealed to the United States Supreme Court and they start to hear the case. So it could be several years off before this case is decided. But I thought I would, if you are living in a condominium and you weren't aware of the litigation, I wanted to make you aware of the litigation. So as you can see, this was fortunately a very slow year for legislation, with the only that are sweeping across the state were the insurance bill and the Canada proposition and the 40-year-old condominium. The other issues, the three bills that have the potential to touch all counties throughout the state, basically Charles County's bill being restrictive to Charles County. So, unless I was wondering if anybody, since we've completed the session, if anybody has any questions about these bills. If you do, please raise your hand. Okay. Well, on behalf of Nora and myself, I'd like to thank everybody for coming today. Certainly, if you have questions and you can come up with after the fact, feel free to reach out to us. We will have the presentation emailed to all participants. And certainly, for my clients that are on the call and managers that I work with, please feel free to give me a call. I've seen that. Oh, I see please, Fern, please ask your question. Thank you.
Could you just talk briefly about the CR5? What is the legal requirement? I mean, is that not a law? Is it just a regulation? I was confused about that.
Yeah, well, yes, that's the operative question. It is a resolution that was adopted by the county council. It is not a law. It was not a bill that was approved. It's a law. In my 20 years of practice, it was the basis of the law was under the ability of the county council to adopt rules regarding the operation of the CCOC, and this is their own CCOC. And this under that theory, this resolution was adopted to regulate community associations. A number of these regulations are in conflict with the state law, are different than the state law. And it's not a law. It was not adopted in the same process that a Prince George's County bill was adopted. So this is a relatively unusual situation that we find ourselves in. And that's why we are recommending that everybody who's within Prince George's County, please contact their lawyers to discuss this resolution, excuse me.
Right. So if somebody wanted to raise a complaint about not having this, they couldn't go to, for example, the Maryland Attorney General's office for this.
The Maryland Attorney General is only authorized to enforce Maryland law. Right. They would not be entitled to enforce county law. So the question is, what could somebody go to court over it? And that remains to be seen, or go to the Prince George's County CCOC to enforce it.
Okay.
And what I will say, just to jump in from Prince George's County, there is going to be more conversation on this, as well as more information to come directly from the commission with respect to this resolution.
Thank you. George?
Yeah. Oops.
Oh, we can hear
Okay,
you.
yeah, I'm not on mute. Good. Yeah, question going forward, if there is any kind of legislation that we would want to see moving forward, to suggest what's the best approach to do so?
So
Either on the county level or the state level.
So Nora can talk to you about the CAI LAC, and I'll let her talk about that. But what we see a lot that is a very effective way is to contact your local state delegate or state senator. Many bills get introduced through that sort of grassroots talking to your delegate, and they introduce bills. And that is one way that has become very effective to getting bills introduced. And certain, organizations and certain communities are very good at building that relationship with their delegate to use politics and to get that done. I'll let Nora talk about working with the CAI LAC.
Okay,
So
great.
there are two components. So we have the National CAI Maryland Legislative Action Committee that's focused on the legislative session to make sure we're advancing proposed acts or proposed legislation that's in favor of common ownership communities. We also have the Maryland Legislative Committee for the local chapter that also works closely on more county level legislation, whether we want to push them forward or we want to object to them. So at the more local level, the chapter's Maryland Legislative Committee meets every month on the first Thursday of every month. And we go over legislation that is being proposed and whether we're supporting it or objecting to it. And then we, as a committee, will file an answer or will file an opinion on them. And then at the Maryland LAC level, we are actively working with lobbyists to advance or to oppose legislation that's coming up before the General Assembly. So there are two components to it. Of course, you're welcome to contact us or to work with, like Jeremy said, to work with senators and local political people directly to get them to either advance or propose or object to things.
Okay, great. Thank you.
Absolutely. Of course. Eleanor?
Yes. Is there, I guess Ms. Hall would probably be able to answer this too. Is there a specific law that requires that the board of directors get training and their certificate before while serving on the board?
Michonne, you're muted. Is this specific to Prince George's County that you're asking?
Yes.
There's a resolution that has a requirement for board member training. And this is as a condition of membership. They must have training. So as I mentioned earlier, there's going to be more information to come because this was a county resolution. However, the commission was not intimately involved in creating this particular language. And so the commission has to come back on their own and suggest changes. So so there's a whole process that needs to take place, and we are working on that right now. So there will be more to come.
Okay, thank you.
Thank you, everyone. I don't see anything in the chat. I'm just giving it one last look. Okay. I think that's all of them.
Thank you.
Thank you. Thank you all.
Thank you, everyone.
Have a great day.
Thank you.
See y'all.